Good morning and welcome to the first Training Thursdays webinar series. I thank you very much for attending. My name is Hermie Abraham and I am an employment lawyer and human resources professional. I have combined 17 years of experience both in human resources and HR, and actually I had an HR career before I started in the area of law. So the purpose for Training Thursdays was basically to help employers address a number of recurring questions that they have in their business about workplace issues. And Training Thursdays is a way to help employers proactively measure some, not measure only, but also manage some of these issues. So today we will be going through one of the top issues that I deal with, managing employee absenteeism and sick leave. But before, a few housekeeping issues. First, this is the first time I'm using this webinar platform, so we might have some technical issues. If there are, I apologize in advance. We're using the Google Hangout platform, and as a result, if you press pause, and this is a live webinar, but if you press pause, you will be able to return from where you left off when you resume. Although the webinar will be live, you won't be live, you will be delayed. So do note that. And from time to time, there might be a slight delay. So I apologize if things might seem out of sync. Hopefully it will flow very smoothly. There is a chat box, so please put your questions in there. I will be taking questions at the end, and there will be opportunity if there's time, perhaps to take a few questions in between. So without further ado, let's get started. So as I mentioned, today we're discussing the thorny issue of employee absenteeism and sick leave. And it is one of the topics that I deal with frequently in my law practice because employers aren't sure exactly what to do with respects to employees who are absent and on leaves. So the topics that we're going to be covering today include a review of the different types of absences, because it's important to have an approach for each of the different types of absences you'll see, to provide an overview about the laws that apply to when you're dealing with sick employees who are on leave, and reviewing some best practices so you can put an absenteeism plan in place for your workplace. But before I start, I wanted to take a poll, and everybody seems to have started voting. Does your organization have a program to manage employee sick leave? So if you can provide your answers, I'll close the poll very shortly. And it looks as if most people have a sick leave policy and program. So that's very good. And I guess the results that we have here in the webinar are different from the results out there in most workplaces. The Conference Board of Canada conducted a survey into absenteeism, and the 2013 report revealed that average absences in Canada range from 9.3 days for full-time employees. So that's essentially 9 days of lost productivity for a workplace. The cost on average to an organization was 2.4% of the gross annual payroll. And what that results in a national scale is a cost to our economy of almost $16.6 billion. And I'm sure that even if you look at your workplace, if you were to look at your total payroll and take close to 2.5% of that payroll, it would be a significant cost that you're losing simply because somebody doesn't show up for work. And these costs don't factor some of the indirect costs of the issues of workplace absenteeism, such as the cost to other employees for the morale, the fact that they have to pick up the slack, the cost for replacing the worker that's absent, the client satisfaction costs that might be damaged as a result of the fact that you're running a tighter ship, and even the reduction in productivity. So if you look at the total cost of an absent employer, it is far greater. And despite the fact that absenteeism comes at such a great cost to a workplace, less than 50% of workplaces have a program to be able to manage and track absences. So for those of you on the call that have a program in place, you're ahead of the game, which is great. And we can see if your program is similar to some of the best practices that I'm going to discuss today. Now, before we get started, it's important to know that there are different types of absenteeism, and it's important to know the different types of absenteeism so you can have a proper plan to address both. So the two types of absenteeism are innocent absenteeism and culpable absenteeism. Innocent absenteeism is your employees who are sick and away from work for bona fide reasons, or they might have childcare or family care responsibilities that cause them from being out of work. They're not necessarily abusing your sick leave policies. They might be using a lot of your sick leave, but it is for a legitimate reason. Culpable or blameworthy absenteeism are those employees who are abusing your sick leave policies. They are asking for leave for no bona fide reason. So perhaps it's the employee who's attending the funeral for the family member that they have been constantly attending a funeral for. And one thing that I tend to see in my law practice is employees who are being performance managed, and simply because they have their employer has raised a workplace issue, they decide that they're going to go on sick leave because they believe that going on sick leave will protect them from being terminated or having any type of action with their performance. And that obviously, as we'll talk about today, is the farthest from the truth. But you should know that that doesn't necessarily mean that it's always blameworthy absenteeism. It's very possible that the stress of being put on a performance management program would cause an employee to go on sick leave. And it's also possible that there might be some other issues that are stressing an employee out that are sort of leading to the poor performance. So it could still fall into the category of being innocent absenteeism. So I'm going to take another poll, or start another poll, so you can go ahead and vote. But the question is, does your organization offer sick leave? And while you're looking at that poll, I'm going to discuss the legal framework with respects to absenteeism. So two main laws are used to address absenteeism and sick leaves in Canada, and that's the Employment Standards Act, employment standards laws generally, and human rights laws. So there are many different legal statutes. The ones that really touch on employee absenteeism and sick leave are the Employment Standards Act and the human rights laws. Now, which law applies to you will greatly depend on, which law applies to you will greatly depend on whether or not you are regulated by provincially in Ontario, or whether or not you are federally regulated. For most of you on the call today, you are probably a provincially regulated employee. People who are federally regulated would be organizations that have an inter-provincial aspect to their work. So there's regulations across the provinces. So employees in banking, telecommunications with the CRTC, transportation, if you think of trains, planes, and automobiles, those employees might be federally regulated, and they would be subject to the Canada Labour Code. But with respects to human rights legislation, fully regulated employees, most federally regulated employees in Ontario will still be under the Ontario Human Rights Code. So if you think of a bank employee that's located in Ontario, they would be regulated by the Human Rights Code and not by the Canadian Human Rights Act. And so we'll look at each of these laws separately. But before, I'm just going to take a look at the answers to the poll. Does your organization have a sick leave policy? 11% have unlimited paid sick leave per year, so that's very generous. 44% have a limited paid sick days per year. Nobody has unpaid sick days, and a few people don't provide sick days to employees. So interesting, almost I would say a 50-50 split between limited sick days and no paid sick days, and a few number who have unlimited. So we'll start looking at the Ontario Employment Standards Act. And one thing that you hear about with the Employment Standards Act, or what the misconception amongst employers, is that the Employment Standards Act has an entitlement for sick leave per se. It does not actually have an actual entitlement for sick leave. What it does require for organizations that have 50 or more employees is that these organizations provide employees with personal emergency leave. And the personal emergency leave is intended for illnesses or injuries of the employee or close family members and dependents. And the law clearly prescribes who those family members and dependents are. I should say that the Employment Standards Act has many other leaves that are available to an employee to help care for a sick or ailing family member. And I'm not going into these leaves in this particular webinar. However, my July webinar that's being held on the employment standards laws will dive a lot deeper into some of these leaves that are available to employees. But regardless of the leave under the Employment Standards Act, including personal emergency leave, you should know that those leaves are unpaid. So an employer does not have a requirement to pay an employee for time away from work if it's a personal emergency leave. So if you have a leave policy that provides days that are unpaid, there's nothing wrong with that. However, at the same time, if you have a workplace of less than 50 employees, so 50 or less than 50 employees, you don't even have to provide leave. So it's you wouldn't be running afoul of the law if you were to do so. The Canada Labour Code is different. Unlike the Employment Standards Act, it does set minimum leave requirements for sick leave requirements for employees who are regulated under the Canada Labour Code. Unlike the Employment Standards Act, it applies to all federally regulated workplaces, so there's no minimum number of employees to have to provide this leave. And the employees are entitled to sick leave only after they've worked for 3 months of continuous service. So there's a bit of a probationary period, if you will, that's built into that. Like the Employment Standards Act, it is job protected leave, so it means that the employee can take the leave without any actions coming against them. And also like the Employment Standards Act, it is unpaid, so there's no requirement for an employer to pay for the leave. Human rights legislation adds another layer to the whole issue of leaves. Human rights legislation doesn't necessarily set standards regarding how much leave an employee should take, like the Employment Standards Act or the Canada Labour Code. Rather, it's meant to ensure that employees who do require time off because of medical issues or even personal family issues do not suffer negative or differential treatment because of the fact that they're taking this leave. And within the human rights complaint process, the ones that actually go in front of a tribunal and are initiated, 50% of them deal with disability claims, and most of those are in employment. So it is a sticky area. Now, the legislation provides that people with disabilities have the right to accommodation to perform the essential duties of their job up to the point of undue hardship. So let's unpack what that means for you as an employer. Disability first, if we're defining it, under the code, it is interpreted very broadly. So it can cover a range of conditions such as a physical impairment, which we think of when we think of disability, but it can also include mental illness, drug and alcohol dependencies, and even something like environmental sensitivities, which people wouldn't often think of as a disability. Now, tribunal decisions have qualified that a disability has to have some degree of permanence which impairs an employee's ability. So, for example, a temporary illness like a cold or a stomach flu or a headache, which is not typically seen as a disability, would not qualify under the Employment Standards Act. So if you have an employee who is presenting themselves and they were constantly, let's say, sick, and so they're taking days off, and they had a flu and stomach flu, and it seems as if they were always having sick days for this particular reason, they wouldn't necessarily have the protection of the Human Rights Code because they're not going to be seen as having a disability. But I do caution you that the Human Rights Commission, which is a policy and sort of helps inform the way the Human Rights Code should be interpreted, it does say that even sometimes minor illnesses or infirmities could be disabilities if an employee can show that he or she was treated unfairly because of the perception of the disability. So if it's a cold or flu, not a disability, but tread carefully if you're going to be providing any type of progressive discipline related to that employee. Now, accommodation also has a specific definition under the code. It is a legal duty that employers are required to follow. And what it means is that employers have to assess the needs of employees who have a disability and provide opportunity for them to be able to participate equally as their other colleagues within the organization. And accommodation is not a unlimited level. Employers don't have to apply accommodation completely. They only have to do so to the need of up to the point of undue hardship. And what this means is that if there could be hardship that's borne on the employer, that might be a limit that the employer reaches and no longer has to provide accommodation. So to use a non-absenteeism example, if an employee had a physical impairment that didn't allow them to, say, easily take the stairs in a building that doesn't have an elevator, an accommodation solution that an employer could propose would be allowing the employee to work on the ground floor, for example. If the employee felt that the only accommodation solution that they could have would be working on the second floor, and it would require the employer installing an elevator or something like that in their building, well, that would probably reach the point of undue hardship because the employer would have to make some major changes within their workplace to be able to accommodate the employee, and that would come at a lot of cost and disruption. So that would be undue hardship, and I wouldn't expect that the employer would be required to make those accommodations. Now, as it relates to absenteeism and any type of illness, providing time away from work for an employee would be considered a reasonable accommodation, and it's very unlikely that an employee's request for time away from work would be seen within the workplace as undue hardship. If the days were incredibly long, then it's possible that you might find that that would be undue hardship. So if there was a long period of time and the employee was central, there might be undue hardship there. But generally, there would not be undue hardship by providing time away from work for employees. Now, we'll go into the human rights laws in far greater detail in the June webinar, where we talk about what the duty to accommodate means, what would be reasonable accommodation, and some of the other areas that employers sort of get caught up in human rights legislation over and above just sick leave. So with that said, let's look at some of the best practices that you can take away so you can better manage absenteeism or sick leave in your workplace. I've come up with 3 best practices that I think will be helpful for you, and these are ones that have worked for some of the employers that I've assisted, and we'll look at each of these in detail. Now, one of the things I should say is that the best practices assume that you're in a non-union environment. If you are in a unionized environment, remember that the collective agreement will dictate what management can and cannot do. However, nothing prevents you from trying to negotiate some of these best practices into the collective agreement in future versions once you're negotiating it. So my first best practice, which it seems as if many of you have, is to create a formal written sick leave policy. And what would make part of that policy first is defining the scope of what really constitutes a sick day. Is a sick day a time for an employee's own illness, or is it time that they can deal with other family issues? There are arguments about whether or not to provide the days as paid or unpaid leave. Legally, as we know, you're not required to provide a time away from work for sick leave or absences as paid time away from work. And I do believe that if you provide a lot of paid time away from work, employees tend to use it as a vacation entitlement, and they will use it similar to a vacation and not necessarily for sick leave. So it might be subject to greater abuse. However, if you don't provide paid time away from work, the other thing that might happen is an employee who is legitimately sick, who should stay at home, will come to work because they don't want to suffer the economic consequence of not being at work, and they might make the other people around them sick with their illness. So my approach is a hybrid approach. I recommend having 3 personal days, and these are not necessarily sick days, but they're general personal days that can be used broadly for any time an employee needs time away from work. And the personal days can be used however they choose fit, consecutively or one at a time. But after those 3 paid personal days, then any time that they want to take away will be unpaid. Now, the paid personal days would have to be clearly made different than vacation. So there wouldn't be carry forward. There's no banking of the days. So if you use it, you lose it. And I find that this limits the people who tend to abuse sick leave policies because, again, if they go over the 3 days, there is an economic penalty or cost to them for doing so. I always say that employers should request medical, and there's nothing wrong, inherently wrong by requesting medical. The information you're requesting should be used to determine the employee's need for accommodation specifically. And remember that as an employer, you're not entitled to diagnosis information, but only prognosis information. So you're not entitled to know why the employee is sick or what the employee is sick of. That you don't need to know what type of illness that they have, but you do need to know about how it will affect the workplace, whether or not they'll need a number of days away from work, whether or not they'll need different accommodations within the workplace to be able to help them be move to regular production as the other employees are in the workplace. When should you request the medical? I say it's not necessarily for the occasional illness here and there. So if somebody's sick and they've only used 2 of their personal days per year, there's no need to sort of get a sick note every time that they call in sick. However, if there are 3 consecutive days, that is a time when you would want to request medical. And if there's a pattern of absences, so an employee is consistently absent for periods of time, whether it's 1 day or 2 days, but in a month they're away at least 2 days or so, definitely that's when you would want to request medical because it's a greater level of absenteeism than you would expect from the other workers. You should also implement an attendance management program, and again, from the looks of it, it seems as if many of you are doing so. The conference board report that I discussed earlier highlighted that a lack of structured absent management program led to increased absenteeism. And I believe that the more employees know about what is required of them with respects to managing their absences, the less likely they will abuse your absence policy. So some attendance management program tips that I recommend is having a way that you can centrally confirm whether an employee is sick. So it could be an email that the employee has to send to a general email within the workplace that's managed by somebody centrally. And this will allow you to track these days so you know which days the employees are taking and whether or not they're paid, if you have sick or paid vacation entitlement, or whether or not they're now using unpaid days. So that would be very important. I say it's also important to share the statistics with the employee. So if you have somebody who is on a pattern of absences or gone a fair bit, I think it's very important that you sit down with them and share the statistics that you have about their pattern of absences, because then they know that you are watching, you are tracking it, and they can again be made to explain why they're having these patterns of absences. And again, look for a way to implement a program to address absences that are longer for 3 days or repeated. One thing that I do with my clients is we have letters that we send out that authorize an employer to get not only particulars about why a person might be needing long periods of time away from work or repeated times away from work, but also enabling the employer to get authorization from the employee's medical practitioner, so the employer can work directly with the medical practitioner, again, not getting diagnosis information, but prognosis information to be able to figure out when the employee will be able to return to normal working capacity. And so if you're able to track, you're far better poised to be able to have a program in place. And the last thing I say is ensure that your program is consistently enforced. If you have only 3 paid personal days, but you tend to be giving away 5 to some employees, and other employees, only are limited to the 3. Or if you have an unpaid vacation policy, or not vacation, sorry, unpaid absence policy, and you find that from time to time, employees have actually been paid for the time that they've been on a sick leave, then you're going to harm your policy's efficacy. Essentially, if the employee raises a stink, whether it's legally or not, if you've paid for the days or the practice that you're running in your workplace, they'll get the greater benefit. So if you're not providing paid vacation, but in some circumstances you might find that an employee who has taken absences that are unpaid will be entitled to having paid vacation or paid absence for those particular days. So be very careful that you're consistently enforcing the policy. And lastly, in terms of best practice, there's nothing wrong with disciplining employees if they abuse sick leave policies, or if you think that there's abuse in the sick leave policy. You have to be careful because, of course, this is where most human rights issues are raised. But I do think that there's a way to manage it so that you can limit your exposure within the human rights forum, but still be able to put the employee's feet to the fire, if you will, to determine why they're taking the absence. So again, if the tracking pattern shows that there's absences and the employee hasn't provided sufficient medical information, they've gone to a walk-in clinic and the walk-in clinic says so-and-so, it needs to be absent for a particular day, you can push back and probe the employee as to specifics why they're unable to come into the office, what they can and cannot do. Understand that under the Human Rights Code, employees also have an obligation to bring accommodation needs to the attention of their employer. And if an employee fails to do so, it's harder for them to claim discrimination on the basis of disability. So if you, by you asking for particulars with respects to how you can accommodate them and them failing to provide it, it's going to be far harder for that employee to be able to raise a disability issue. And on top of it, once you're able to see if they don't provide information that will allow you to clearly substantiate why they're on leave or why they've taken these sick days, you can discipline them. And I always recommend a progressive discipline program where you would start with a written warning, letting them know of the infraction, letting them know what's expected of them in terms of standards, and then monitoring, tracking, and following up, both during the course of the progressive discipline when you're monitoring their performance, and after, to see if there's any slips, to be able to bring it to their attention and manage it tightly. And of course, through the progressive discipline program, you always want to make sure that you're documenting. So that's all I have. I'm sorry I've gone a little over time, but I will stay for questions if there are any. So if you have questions, please enter them into the chat box now, and I will answer them. And I don't see any questions yet. I'll say this. What about chronic lateness? So if somebody is chronically late, again, many of these best practices do apply. You can probe and find out why the employee is late for whatever reason. If it relates to illness or disability, again, if it's cold, flu, something like that, recognize that they don't have the protections of the Human Rights Code, and you can progressively discipline them. I say that progressive discipline is the best way that employers can start to put an employee on notice of the fact that they're not meeting the standards and that there's a good chance that they can lose their job. And if you have instituted a progressive discipline program and over time there hasn't been improvement, you do have the opportunity of terminating employee either for a cause, if it's serious enough, or on a without cause basis, with less chance that the employee, again, will be able to bring forward a human rights issue because of the fact that you've given them the opportunity to come to you and meet this and discuss the reasons why they were unable to come to work on time, or even the reasons why they needed to take this time away from work. So that definitely will go far. And again, if you have questions specifically, be happy to follow up and discuss your particular area. Kate has a question. Do others offer personal time off not paid, but employee must pay back the time? That's a really good question, and it's a difficult and sticky area because you don't want to necessarily penalize an employee, especially again if there's innocent absenteeism. And if I'm interpreting your question correctly, it's the fact that the employers have personal time off that is possibly paid, and if the employee goes over, I guess, a certain entitlement, then they have to pay it back. It might be seen as a penalty, and if there's any type of penalty, there's a chance that an employer would be seen as sort of treating or discriminating against a disabled employee if it's innocent absenteeism. So I'd say that any type of paying out, so let's say if you offer 3 unpaid days and you pay them out at the end of the year, or if you make employees pay for time, that would be problematic. It's best to just provide a set entitlement, and anything over that entitlement is unpaid, and the entitlement to be used, and if you don't use it, then you lose it. And Kate qualifies to say that a person's not sick but needs time away for an appointment or family situation. And that's why I recommend having personal days, because personal days allow it to be anything. And we'll again talk about this in greater detail when we look at the webinar with the human rights laws. But it could very well be that it could be for religious observance or something else. And if you provide personal days rather than sick days specifically, then the employee can manage it as they see fit. They can use it or lose it, and you're not going to run into the issue of looking as if you're penalizing somebody under the Human Rights Code. And just so you know, there will be a broadcast, a replay, a link for you if you want to listen to the webinar again. And I will be providing people with tip sheets with respect to the webinar. That should be coming out in your email tomorrow. If you have any questions, there is my email address, info@advocation.ca. So please feel free to send me an email. I thank everybody for the time that you spent with me this morning. I know your time is important, and I thank you very much for sharing it with me, and I send you great wishes for a productive day. Thank you very much.